Honorable Mr. Justice, retired Judge of the Honorable Supreme Court, Justice Samad Jalal Usmani Saab. Honorable Mr. Justice, retired Mushir Alam Saab, the Judge of the Honorable Supreme Court. Mr. Justice Shafi Siddiqui Saab, Senior Puisne Judge of the High Court of Sindh. My brothers from the High Courts in KPK, Balochistan, Punjab, Islamabad, Gilgit-Baltistan, Barrister Mia Shiraz Saab. Ladies and gentlemen, Assalamu Alaikum. It's always a pleasure to stand before you and such an august gathering, and as we have been highly induced by the knowledge of the last many speakers, I had taken the trouble to put out, first of all, the Pakistan's energy map so that we can see what are the issues and what are the disputes that arises and how can they be minimized and what do we need to do to resolve them. I'm sorry you can't see that because this TV is not working. The Pakistan's overall energy needs as they stand sometime in the year 2022 are comprised of the fossil fuels, which are coal, oil, gas, electricity, which is mostly generated by fossil fuels, except very little from the nuclear energies and the biomass. The fossil fuels, as you can see from this point down, probably constitute about 70% of our energy needs. The rest comes from the biomass, which is animal waste, crop waste, and very interestingly, this whole chunk, which comprises of nearly 30% of the Pakistan's energy need, is in completely informal sector. And this being in informal sector, you can see that so far, I have not come across any disputes arising in this sector because it's been completely regulated, mediated, resolved by the players themselves. The entire bulk of legal disputes is in this range, which is 70% and coming out of the highly regulated industry, which is be the coal, be the oil, the gas, or the electricity. So we will see that how it is that the more you start regulating a process, how many number of disputes arise in that area. So we'll go one by one. No, I won't take much of the time. So the coal disputes are primarily with regard to mining and lease disputes, the import disputes that these courts are mostly interested with, storage disputes, which are primarily the environmental concerns related to coal. And our courts normally have these three kinds of disputes, and I do not, the Coal Authority is the body that regulates the import of coals. There's a coal mine rules recently promulgated, and there's a Coal Authority Act available. But there's no provision of arbitration, mediation, or dispute resolution as far as the coal is concerned. And coal not forming much of the energy needs is not really much discussed here. ONG is the main sector. We'll come to electricity where the large number of disputes arise. Is oil and gas is the sector which is highly regulated by OGRA. And our courts, and I think all the courts, even the Supreme Court, are always have to decide many cases pertaining to oil and gas sectors. Only last month, the ICC upheld Pakistan's jurisdiction over a dispute with regard to oil exploration and oil sector. One of the trouble that facing the entire oil gas sector, as well as the electricity sector, is the government sector debts and dues that they need to pay. ONG itself requires government to pay 1.5 trillion rupees to clear its debts off. The disputes in oil and gas also that comes to the courts are with regard to tariff. We're always, because the mechanism by OGRA is I would say such a cumbersome process even being a lawyer, being an engineer, being a judge, it's very, very difficult to even understand the methodology and the complex equations that form how, in one of my judgments, I actually tried to copy a judgment, tried to copy an equation, which probably have differential equations in it, which probably judges or not, even arbitrators or mediators can't understand probably, unless they have very strong math skills. The other disputes that come to us before the courts are generation disputes and the supply disputes, which are, again, the OGRA uses its, I would say, highly regulated monopoly to fix prices, the gas supply prices, in various parts of the country at various different rates. So there's always a disbalance between the tariff available. In ONG, the reason that the delays cause oil and gas exploration company is that because the disputes are not resolved. No ONG company would like to invest where the disputes are still handling, and the government somehow so far has no mechanism to mediate these disputes, arbitrate these disputes. This is one of the clip from the newspaper. Now coming to the power disputes, which is probably the area we're all, at least in the urban part of the country, is a very interesting that in the last, how the landscape has changed over the last 4 or 5 years, for example. In the year 2015, the electric producing companies, if you look into this chart, it's primarily comprised of 2 blocks, that green blocks and the blue block. These middle bands are nearly similar, so in this interest of time, I will not discuss this. But if you look into the blue block, there's the energy charge. That is the cost of nearly producing the energy. This is the cost of using the system. This is transmission and distribution losses. This is the distributor's margin. This is last year's adjustments. But the most important element here, as you see, is the capacity charge. The capacity charge is the recurring debt. And if you see this graph from the year 2015 to 2022, this green block is inflating like a balloon. Today, Pakistan's 5% of the GNP, which is about 5.5 trillion rupees, is stuck in this green block. And you see how it is changing over the years. And these are those IPPs and other government subsidies that are not paid and keep on adding to the cost of the service. This balloon is very, very important to keep in mind, that if we can resolve this, and this amounts to, between the last, every day, there is about like more than 200 billion rupees added to this green block. In the last 2 days, we've added 5 billion rupees as a circular debt within the country's power supply sector. So how important is this? And this is where we might have dispute resolution adjudication probably in this sector, but the biggest sector is this, for which we do not have any sectors, so except the negotiations which were going on, but obviously not much help so far. NEPRA is the regulatory authority that is responsible to award licenses, have tariff determination, consumer complaints, overall regulation, and disputes regulation is a part of the NEPRA's law, has now being built to this round. But a lot of the work that the courts are busy with are in these 3 sectors. Licenses, tariff takes a lot of our time, and most of the judgments you will see arising from all the high courts and even the Supreme Court are coming on these tariff sides, because as I said, the complicated formula to determine tariff is nobody can understand except those there at the helm of the affairs. And why do we have that? Such a complicated formula is just obviously best known to them. This is Pakistan's dispute summary for the last 10 years. We had actually UNDAC. We have 3 disputes that went to UNCTAD, and in the last 10 years, I think more than 12 disputes have overall gone, the latest is being with Turkey and Saudi Arabia. What's the future? Something have been shown this time. I think the biggest challenge with us is the resource development. I think each and every speaker has emphasized this. And the resource development of lawyers to deal with international disputes. What happened at Kake, what happened with Yadev Kalboshan is just all known to us. That this $5 billion that we had to pay is again an act that could have been avoided by bringing in lawyers, bringing in good resources. Behind all of this, the lady from the World Bank raised a very innocent question: why it takes 15 days to list out a person on the list to have a dispute? This is the word for it. They will take, every player is playing with his names, with his numbers, who want to be listed on that list. So if 15 days takes place, I think, which probably considering circumstances is not that bad. Modern laws, we need to modernize. We still have the Electricity Act of 1911 or something, when electricity was invented actually by whatever. So we still have that. Most important thing that we find is that missing in the government sector is the beneficial interpretation. They think they're ruling a different country. The people, the consumers are aliens to them. There's no concept of beneficial interpretation. If there could have been beneficial interpretation at the original side, these such disputes will never arise. As we just started the renewable energy resources, the more and more we go into that, we will be solving a lot of the energy disputes. The UK case is that there's an energy ombudsman. So we can have an ombudsman available in the energy sector. So the biggest trouble, again, before I conclude with that and leave to thought, is that in the country, there are probably, I was listing now, there are more than 10 regulators. NADRA is a regulator, PIPRA, these are all regulators, the electricity regulator, NEPRA. Whenever you have a regulator, the biggest question posed is that who regulates the regulator? Are regulators independent, divine entities that cannot be challenged? No. Every country with our regulators, there are who regulates the regulators is important. Here we just go, every decision from the regulator comes for the challenge.